Good day, future lawyers. This is part 3 of our criminal law review. Let's begin. The provision on conspiracy under Article 8 of the Revised Penal Code can be suppletorily applied to Republic Act No. 9262. Section 3 of RE 9262 defines violence against women and their children as any act or a series of acts committed by any person against a woman who is his wife, former wife, or against a woman with whom the person has or had a sexual or dating relationship, or with whom he has a common child, or against her child, whether legitimate or illegitimate, within or without the family abode, which result in or is likely to result in physical, sexual, psychological harm or suffering, or economic abuse, including threats of such acts, battery, assault, coercion, harassment, or arbitrary deprivation of liberty. While the said provision provides that the offender be related or connected to the victim by marriage, former marriage, or a sexual or dating relationship, it does not preclude the application of the principle of conspiracy under the Revised Penal Code. Section 47 of RE number 9262 expressly provides for the supplementary application of the Revised Penal Code. For purposes of this Act, the Revised Penal Code and other applicable laws shall have supplementary application. Thus, the principle of conspiracy may be applied to Republic Act No. 9262. For one's conspiracy or action in concert to achieve a criminal design is shown, the act of one is the act of all the conspirators, and the precise extent or modality of participation of each of them becomes secondary, since all the conspirators are principals. Lesbian relationships are covered in Republic Act No. 9262. The Supreme Court ruled in Garcia versus Trilon, a June 2013 case, that there is no merit to the contention that Republic Act 9262 singles out the husband or father as the culprit. As defined, vowsy may likewise be committed against a woman with whom the person has or had a sexual or dating relationship. Clearly, the use of the gender-neutral word person who has or had a sexual or dating relationship with a woman encompasses even lesbian relationships. Technical malversation. The crime of technical malversation, as penalized under Article 220 of the Revised Penal Code, has 3 elements. A. That the offender is an accountable public officer. B. That he applies public funds or property under his administration to some public use. And C. That the public use for which such funds or property were applied is different from the purpose for which they were originally appropriated by law or ordinance. Criminal intent is not an element of technical malversation. The law punishes the act of diverting public property earmarked by law or ordinance for a particular public purpose to another public purpose. The offense is mala prohibita, meaning that the prohibited act is not inherently immoral but becomes a criminal offense because positive law forbids its commission based on considerations of public policy, order, and convenience. It is the commission of an act as defined by law and not the character or effect thereof that determines whether or not the provision has been violated. Hence, malice or criminal intent is completely irrelevant. Moving on, for a conviction of the crime of robbery with rape to stand, it must be shown that the rape was committed by reason or on the occasion of a robbery and not the other way around. This special complex crime under Article 294 of the Revised Penal Code contemplates a situation where the original intent of the accused was to take, with intent to gain, personal property belonging to another, and rape is committed on the occasion thereof, or as an accompanying crime. Thus, to be convicted of robbery with rape, the following elements must concur. 1. The taking of personal property is committed with violence or intimidation against persons. 2. The property taken belongs to another. 3. The taking is characterized by intent to gain or animus lucrandi. And 4. The robbery is accompanied by rape. Next, direct assault with murder. The phrase on occasion of such performance, used in Article 148 of the Revised Penal Code, means by reason of the past performance of official duty, because the purpose of the law is to allow them to discharge their duties without fear of being assaulted by reason thereof. For example, attacking a judge by reason of past performance of duty of convicting the accused based on his assessment of the evidences constitutes qualified direct assault. Since the single act of attacking the judge constitutes direct assault and murder qualified by the circumstances of treachery, the two shall be merged together to form a complex crime of direct assault with murder. Disregard of rank being inherent in direct assault is absorbed. The elements of forcible abduction. Under Article 342 of the Revised Penal Code, the elements of forcible abduction are 1. The taking of a woman against her will, and with lewd designs. The crime of forcible abduction with rape is a complex crime that occurs when the abductor has carnal knowledge of the abducted woman under the following circumstances. 1. By using force or intimidation. 2. When the woman is deprived of reason or otherwise unconscious. And 3. When the woman is under 12 years of age or is demented. Where the main objective of the culprit for the abduction of the victim of rape was to have carnal knowledge of her, he could be convicted only of rape. Identification of dangerous drugs. In all prosecutions for violation of Republic Act 9165, the corpus delicti is the dangerous drug itself. Its existence is essential to a judgment of conviction. Hence, the identity of the dangerous drugs must be clearly established. Narcotic substances are not readily identifiable. To determine their composition and nature, they must undergo scientific testing and analysis. Narcotic substances are also highly susceptible to alteration, tampering, or contamination. It is imperative, therefore, that the drugs allegedly seized from the accused are the very same objects tested in the laboratory and offered in court as evidence. The chain of custody as a method of authentication ensures that unnecessary doubts involving the identity of seized drugs are removed. Moving on, serious illegal detention or kidnapping with ransom is punished under Article 267 of the Revised Penal Code. The following elements must concur. A. The offender is a private individual. He kidnaps or detains another, or in any manner deprives the latter of his liberty. The act of detention or kidnapping must be illegal, and in the commission of the offense, any of the following circumstances is present. 1. The kidnapping or detention lasts for more than 3 days. 2. It is committed by simulating public authority. 3. Any serious physical injuries are inflicted upon the person kidnapped or detained, or threats to kill him are made. Or 4. The person kidnapped or detained is a minor, female, or a public officer. In addition, the maximum penalty of death is imposable should the purpose of the detention or kidnapping was to extort money, even if qualifying circumstances mentioned in Article 267 are not present. People v. Fajardo, April 2018. In order to prove kidnapping, the prosecution must establish that the victim was forcefully transported, locked up, or restrained. It must be proved that the accused intended to deprive the victim of his liberty. People v. Avansana, June 2017. The illegal detention coupled with a demand for money is tantamount to serious illegal detention or kidnapping, punishable under Article 267 of the Revised Penal Code. The demand for ransom consummates the crime of serious illegal detention or kidnapping because the actual payment or receipt by the kidnappers of the money is immaterial. People v. Fajardo, April 2018. Reckless imprudence consists in voluntary but without malice doing or failing to do an act from which material damage results by reason of inexcusable lack of precaution on the part of the person performing or failing to perform such act, taking into consideration his employment or occupation, degree of intelligence, physical condition, and other circumstances regarding persons, time, and place. Prior conviction or acquittal of reckless imprudence bars subsequent prosecution for the same quasi-offense. The doctrine that reckless imprudence under Article 365 is a single quasi-offense by itself and not merely a means to commit other crimes, such that conviction or acquittal of such quasi-offense bars subsequent prosecution for the same quasi-offense, regardless of its various resulting acts, undergirded this court's unbroken chain of jurisprudence on double jeopardy as applied to Article 365. Ivler v. Modesto San Pedro, November 2010. Murder is committed when a person is killed under any of the circumstances enumerated under Article 248 of the Revised Penal Code as amended. Article 248. Murder. Any person who, not falling within the provisions of Article 246, shall kill another, shall be guilty of murder, and shall be punished by reclusion perpetua to death if committed with any of the following attendant circumstances. 1. With treachery, taking advantage of superior strength, with the aid of armed men, or employing means to weaken the defense or of means or persons to ensure or afford impunity. 2. In consideration of a prize, reward, or promise. 3. By means of inundation, fire, poison, explosion, shipwreck, stranding of a vessel, derailment, or assault upon a railroad, fall of an airship, or by means of motor vehicles, or with the use of any other means involving great waste and ruin. 4. On occasion of any of the calamities enumerated in the preceding paragraph, or of an earthquake, eruption of a volcano, destructive cyclone, epidemic, or other public calamity. 5. With evident premeditation. 6. With cruelty by deliberately and inhumanly augmenting the suffering of the victim, or outraging or scoffing at his person or corpse. To sustain a conviction under Article 248 of the Revised Penal Code, the prosecution must prove the following beyond reasonable doubt. 1. That a person was killed. 2. That the accused appellants killed the victim. 3. That the killing was not parricide or infanticide. And 4. That the killing was attended by any of the qualifying circumstances under Article 248. We're done. Thank you so much for watching.